Hello everyone, welcome to Conquer Learning and welcome to the last video of the Industrial Dispute Act 1947. We have till now completed the part 3 and have covered up very important sections or provisions of this particular legislation. So today we are going to finish up this and this is the part 4. In last video we have covered the chapter number 5A. Now we are going to cover up chapter number 5B. Before we move to chapter number 5A, we would be understanding what is the difference between 5A and 5B. So, chapter number 5A deals with the provisions related to layoff, retrenchment, closure. Now, this chapter number 5A is applicable to those establishments, those industrial establishments where less than 100, how many? Less than 100 employees are working. And chapter number 5B, the provisions are related to again layoff, retrenchment, closure. But this is applicable to 100 or more. So as soon as any establishment has 100 or 101 or more employees, the chapter number 5B becomes applicable. Whereas if there are 99 or lesser employees, the chapter 5A is applicable. That is the difference between 5A, 5B. Only the provisions are layoff, retrenchment, closure. Again, here also layoff, retrenchment and closure. Now, there are certain difference in the provisions. We would be studying them actual difference. Now, before we move to the actual chapter number 5B, we need to also remember that this provisions has been introduced after the important amendments made in the Industrial Dispute Act. So, chapter number 5B was inserted in 1976. The amendment was specifically for the special provisions relating to layoff, retrenchment, closure in certain establishment called as chapter number 5B. Now this certain establishment is also defined here. Chapter number 5A, we don't have the definition for the establishment. But under chapter 5B, we have the definition for certain establishment. Means this is applicable to factories, plantation and mines. We will be studying in the next slide as well that where is this applicable. So specially they are applicable to factories, plants and mines. Section 25K talks about application of chapter number 5B. Now, where the provision of this particular chapters are applicable. So, the provision of this chapter shall apply to an industrial establishment which not less than 100 workmen were employed on an average per working day for preceding 12 months. This is what I explained to you here, that at least 100 or more those establishment the chapter is applicable. It is not applicable an establishment which is of seasonal character or where the work is performed on intermediate. So it's not applicable on seasonal and intermediate character. You can say the establishment. Only factories, plantation and mine, means these are the certain establishment defined. We will be studying in next slide, 100 or more. Now, if the question arises whether the establishment of seasonal character or whether it is of intermediate nature or not, this decision would be final decision of the appropriate government. So appropriate government would be finally deciding whether it is a seasonal or non-seasonal character establishment, whether the work is intermediate or permanent in nature. Now, what is the industrial establishment here? For this particular chapter, we will be talking about chapter number 5B. So when we have to make the application of provision of chapter 5B, we will be making an application on certain establishment. What all establishments are covered here? So factory as defined under the Factories Act, mine as defined in the Mines Act, and plantation as defined in the Plantation Labor Act. No, notwithstanding any content in subclause 2 of the clause A, section of 2. So this is again this about this clarification. We will come to that as well. But you remember, it is applicable to factory, it is applicable to mine, and it is applicable to the plantation. Now another condition here is, if there is any company which is not less than 50%, which is holding not less than 50, in which not less than 51% of paid up share capital is held by the central government. So any company which is whose 51 share, at least how much, 51 paid up share are held by the central government, the provisions would be applicable. Second clause, in relation to any cooperation not being a cooperated referred in subclause 1 of A, subclause 1 of A of section 2 established under any law of parliament, the central government shall be appropriate government. So where the cooperation is not that is referred in this particular one clause, there the central government would be the appropriate government. This is something which you don't have to remember that in detail, just you need to remember that this particular chapter 5b is applicable factory, mine, plantation where 100 or more employees are employed in last preceding 12 months. Now let's move to the section number 25M, which talks about prohibition of layoff. In chapter number 5A, we studied that any person who has completed continuous service of 1 year in any of the establishment, the employer before laying off him, they have to can lay off that person to maximum 45 days, and anybody who is being laid off is supposed to get the layoff compensation. Now what is condition under chapter number 5b? This says that no workmen other than badli workmen or casual, so no workmen means any of the workmen won't be whose name is prone in muster rolls in this industrial establishment, means anyone whose name is in the register, whose name is enrolled in the industrial establishment, won't be laid off normally. So what is the condition? With the prior permission of the appropriate government. So the prior permission in chapter number 5a, there was no such prior permission. It was just to notify. They have to notify. Notice, giving the notice is like you are informing. Prior permission is like you are asking whether I can lay off or not. So that is the difference between, in chapter number 5a it is notifying, in chapter number 5b it is prior permission, asking for the permission. So before making any layoff, they have to take a prior permission from the appropriate government or such authority which may be specified by the government. Then obtained on an application made in this behalf, unless such layoff is due to the shortage of power. Second thing, they have to make an application, and the layoff can be only due to the shortage of power, natural calamity. In case of mine, the layoff is due to the fire, flood, excess of inflammable gas or explosion. The permission has to be given by the government, and the application which is being sent to the government for the permission should have everything stated clearly, the reasons why they are laying off, and the copy of application shall be served simultaneously to the workmen concerned in prescribed manner. Means it would be even given to the workmen, trade unions, that yes, they or this particular workmen that they are going to be laid off. The employer in relation to such shall within period of 30 days from days of commencement of such layoff apply in prescribed manner to appropriate government or the specified authority for prior permission. So how many days? 30 days notification, 30 days application has to be given for prior permission. Now, in case where an application or the permission by the specified authority, means I am the employer, I made 30 days application to the appropriate government for asking for permission of layoff. So now after making an application, the appropriate government has not communicated me anything. They have not communicated me anything, whether it is rejected or whether it is approved for the period of 60 days. Then after the expiry of this 60 days, it would be considered as deemed approved. मतलब आपने as an appropriate government आंसर नहीं किया कि हाँ ये approved है या rejected है, तो आपका 60 डेज के बाद में वो डीम्ड अप्रूवल कहलाता है. सो प्लीज रिमेंबर, अंडर दिस प्रोहिबिशन ऑफ द ले ऑफ, नो वर्कमैन कैन बी लेड ऑफ without taking the prior permission from the government. The permission has to be taken for 30 days, and in case it is not communicated for the time period of 60 days, after the expiry of 60 days, it is considered as the deemed approval. This is the provisions related to the layoff. Now, conditions precedents for the retrenchment of the workmen. Now, we have studied in the chapter number 5a that any person who has completed the continuous service of 1 year is supposed to get the notice of 1 month before he is being retrenched. Whereas in chapter number 5b, under the section 25n, any workman who is in any industrial establishment who has been in the continuous service not less than 1 year, if the employer is planning to retrench that person, the notice has to be given at least for 3 months in writing, indicating the reasons for the retrenchment, the period of the notice has expired, or the workman. So the first thing is that in chapter 5a, it was 1 month notice. In chapter 5b, it is 3 months notice with the clear reasons why they are being retrenched. Second, or the workman has been paid the amount. If you are not giving the notice, you have to pay him the salary. Wages for the period are supposed to be paid. Second important thing, before you retrench anyone, the prior permission of the appropriate government or the authority is to be specified. In chapter number 5a, there was the notice of 1 month and notification was to the appropriate government. There was notice to the appropriate government. Here it's permission. So 3 months notice to the workmen and prior permission from the government. Now, in case the employer has made an application, in how many days, or if in any case they have not communicated the reason, they have not communicated, who the appropriate government has not communicated that it is approved or it is rejected within 60 days of such application, after the expiry of 60 days, it is considered to be deemed approval, exactly as that of the layoff. So an application for the permission shall be made by the employer in a prescribed manner, clearly stating the reasons of intended retrenchment. Copy of application shall be served to simultaneously to workmen. Where an application for the permission has been made, the appropriate government, after making inquiry, if it thinks after giving a reasonable opportunity being heard, the workman consent, the person interested may, having regard genuineness, adequacy of reason stated. So it is like once the appropriate government receives the application, it would go through the detail and then only it would communicate whether it is accepted or rejected. And such grant permission, when it is granted, the copy has to be communicated to the employer and the workmen. So these are the conditions for the retrenchment. Identify the difference between the chapter number 5a and chapter number 5b. Clear? Let's move. So now again the 60 days to, which I have already explained you, that if an application was made to an appropriate government and appropriate government has not communicated within the 60 days, after the expiry of 60 days, it would be considered as the deemed approval. Clear? Now, whatever order, whether it is approved or whether it is rejected, whatever order appropriate government gives to the employer, it would be in force for 1 year from the date of such order. It means what? Suppose I have made an employer, I am an employer, I made an application to the appropriate government. Appropriate government has communicated. There can be two cases. First, not communicated. If they have not communicated, after 60 days expiry, it would be deemed approval. But if it is communicated, so it can be now again either approved or either rejected. So whatever has been communicated, it would be in operation for the duration of 1 year. So means if they have rejected for next 1 year, you cannot retrench anyone. So it would be in application for 1 year. So now the appropriate government or by the specified authority, either by its own motion or application by the employer or any work, review in order granting or refusing the grant permission. So it can be reviewed also. Whenever they are giving a granting permission, it can be reviewed, provided that where a reference has been made to a tribunal under subsection, it shall be passed an award within the period of 30 days. Now, review, and suppose it is referred to the tribunal for the adjudication. So, suppose they have rejected, appropriate government rejected. So, employer goes and make an appeal to the tribunal, industrial tribunal. So, whenever it is referred to industrial tribunal, the industrial tribunal will make or give the final award, will make the decision within 30 days. Clear? So this is the retrenchment. Next comes your section number 25O, procedure for closing down an undertaking. In chapter number 5A, there was the condition for 60 days. The employer who is going to close or who is intending to close down the establishment is supposed to give the 60 days notice. But in chapter number 5B, it is required to take the prior permission before you close and send the copy to the workmen. But it is not applicable to undertaking which are set up for the construction bridges and canals. Now government, now here the prior permission is supposed to be, or the permission has to be given, the notice has to be given of 90 days. It is 90 days here. It was 60 days in chapter number 5A. Here it is 90 days notice has to be given. So government, now again I made an application to appropriate government. I made a prior application. So appropriate government either can reject or either can approve. They have to do this in the duration of 60 days. In case they have not communicated anything, it is deemed to be approved for after the expiry of 60 days, and it would be in application if they have communicated, rejected or approved. It would be in application for the duration of 1 year. Next comes your section number 25P, which says the special provisions of restarting the undertaking which is closed down. Now suppose some industrial establishment was closed down due to some reason. So our Industrial Relation Act has a provision that the industrial establishment can be again restarted. But before restarting, it is made sure that it does not put an hardship on employer. So undertaking closed down before the commencement of Industrial Dispute Act. It means suppose this is an industry which was closed down before the law became applicable, before the amendment happened in 19. So actually this special provision was introduced in 1976. So if the industrial establishment has been closed down before 1976, it can be restarted on account of, if the reason was unavoidable circumstances, it can be restarted for rehabilitation of workmen, but making sure that restarting of undertaking will not result in hardship of employer in relation to undertaking. An appropriate government can give the order for restarting. So this was amended in the 1976. Now let's move to the next provisions, that are unfair labor practices. Now this can be from both the sides, employee and employer side. The list of the unfair labor practices are given in the 5th schedule. What are, or what do you mean by unfair labor practices? Those actions, those practices which are carried out with the bad faith for doing something wrong with other is called as the unfair labor practices. Section number 25T says prohibition, that either it is the trade union, either it is the employee, either it is the workman, or it is the employer both of them are prohibited to carry out, to commit any kind of unfair labor practice. So no employer or workman or a trade union, whether registered under the Trade Unions Act 1926, no or not, shall commit any unfair labor practice. Now this is the point of the question. Usually in exam the question are asked. So employer's unfair labor practice. When is employer considered to be doing an unfair labor practice? If he interfere with restrained workmen in exercise. So if he is not allowing any of the employee to join trade union, he is not allowing any of the employee to enter into collective bargaining process, it is unfair. If you are threatening workmen with discharge, कह दे आप, if you are saying that अगर आप काम नहीं करोगे हम आपको discharge कर देंगे, dismiss कर देंगे, lockout कर देंगे, no, this is unfair. Dominate interference with the contribution of financial support. If you are interfering in the formation of trade union by saying that we will be supporting you financially but it would be our control, no. To establish employer sponsored, so this is called as company union, where the employers having the maximum domination. Victimization, you are not going to involve or not put any false cases on the workmen, false allegations or workmen. You are not going to abolish the work of which is regular nature. You won't show any favoritism, illegal recruitment, failure to. So these are all unfair labor practices from employer side. Employee side, they won't go on illegal strike. To picketing. Picketing means what? Demonstration which is done at the gates of the you can say the gates of the industrial establishment. They stands with the banner and they try to protest. So that is not. So picketing in such a manner that non-striking workmen are physically debarred and entering from the. So picketing, you won't ask anyone who is not ready to strike to come with you. Refuse collective bargaining with the employer. To stage demonstration. So residence of the owner, you are मेकिंग डिमॉन्स्ट्रेशन, वहां पे जाके दंगा कर रहे हो, वहां पे जाके कर रहे हो, सो दैट इज नॉट appreciable. To damage employers property or industries, so you are damaging. Violence, threatening other workmen from attending the work, these all are unfair labor practices from the employees side. Now we come to our penalties. Section number 225Q, penalty for layoff, retrenchment without previous permission. This is for the special provision given in chapter number 5B. If without permission you are retrenching someone, imprisonment extended to 1 month or fine of 1,000 rupees. Penalty for closure, if you are closing without giving the notice, either 60 days or either 90 days, either chapter 5A or chapter 5B, imprisonment extended to 6 months, 5,000 rupees or both. Penalty for committing unfair labor practice, imprisonment of extended to 6 months, fine of 1,000. Penalty for illegal strikes and illegal lockouts. Strikes, if it is imprisonment, if it is a strike, it would be imprisonment of 1 month, fine of 50, and if it is the lockout, 1 month, fine of 1,000. Penalty for initiation forces inside. So in case of strikes and lockout, if you are asking forcefully someone to participate, you are forcefully asking someone to come and participate, imprisonment of 6 months, 1,000 rupees, fine. So these were the penalties. Another penalty for illegal strike, financial aid. If you are giving financial help to illegal strikes, imprisonment for 6 months, 1,000 rupees, fine. Penalty for breach of settlement or award. The settlement has arisen, the award has arisen. You are supposed to make it in operation and you have to act in that way. But you are not acting it, you are breaking it. Imprisonment extended to the term of 6 months or fine or both. Extended fine of 200 rupees further. Once you have done it, again continuously you are doing it. So further contravention. Penalty for other offences like pendency of the proceeding. So now if there are any proceeding pending and during that point of the time you are going on strike, which is illegal, imprisonment of 6 months and 1,000 rupees fine or both. Clear? So these were the penalties. Very important section is section number 61, which is given in the rules of industrial dispute rules. It is not in the act. In the act it is mentioned in section number 33 clause 3. Protected workmen. Now, what is protected workmen? Every trade union which is registered in the industrial establishment is supposed to give a list of the office bearer to the employer before the 30th April with the name and address of such office bearers and the union employed in establishment, and the employer would declare or recognize at least 1% of this total workmen whose ever list is given, or minimum 5 to maximum 100 as protected workmen. So this protected workmen, the list is given by registered trade union to the employer. Employer recognizes at least 1% of total workmen, minimum 5, maximum to 100. Now the protection given to this protected workman is that any of the dispute related to this particular trade union is taken to the central regional labor commissioner, central assistant labor commissioner. So very important, number of the time the question has been asked that what is protected workmen and what percentage are declared or recognized as the protected workmen. So this was the Industrial Dispute Act 1947. I will just quickly cover the subsequent amendments which has happened. Since you have studied complete Industrial Dispute Act, it would be easy to cover the amendment. So first amendment was introduced in 1949, which was to remove difficulties created by piecemeal. So earlier, before 1949 amendment, there was the disputes, or there were the adjudication or disputes were settled in the pieces, means there were number of the offices, or you can say number of the branches, but it was removed. So by at removing difficulties created by piecemeal adjudication of dispute in banking, insurance, company heavy branches, one or more state replaced the Industrial Dispute Banking Ordinance. Next was amendment in 1950, which the further amendment was Industrial Dispute Appellant Tribunal Act, which provided the establishment of Labor Appellant Tribunal. So you may have the question, when was Labor Appellant Tribunal introduced? It was in 1950, and it was pertaining to enforcement of award power of tribunal. It was given a power to make enforce the award and tribunals to hear complaint regarding alteration of services of condition during pendency of proceeding, representation, recovery of the employer. So the thing that you need to remember about this particular amendment is that Labor Appellant Tribunal was introduced. 1952, it replaced the Industrial Dispute Amendment Ordinance 1951 and widened the power of government to refer the industrial dispute to the Board of Conciliation, Court of Inquiry and Tribunal. Not that important, but remember that the power was given to the government to refer the dispute to Conciliation, Court of Inquiry and Tribunal. 53, the conditions for the layoff and retrenchment compensation was introduced through the Chapter 5A. So it was 1953 when Chapter number 5A was introduced in Industrial Dispute Act. 1954, which extended the provisions of laying off retrenchment in plantation. 56, specified the circumstances under which the compensation of layoff could be extended beyond first 45 days of layoff. So there was certain circumstances where the layoff can be extended beyond the 45 days. So those circumstances were given in 1956. 1971 amendment widened the power of labor court, tribunal and national tribunal in course of adjudication proceeding of dismissal, discharge. So this was like any person who is dismissed, discharged or retrenched. In that case, if the employer has dismissed or discharged, so labor court, tribunals and national tribunal were given a power that they can keep this decision aside and give their own separate decision. So that was introduced in the 1951. 1972, The closure, the condition for 60 days closure before the closure was introduced in 1972. The amendment did not apply. So this conditions that it won't be applied. So closure of 60 days notice does not apply to the undertaking where there are less than 50 worker. This everything was introduced in 1972. So please remember, Amendment 1976, it inserted the chapter number 5, which is a special provision applies to 100 or more employees working in industrial establishment. 1982, it provided the objective bill for the speedy resolution as a result of National Commission Labor. So, speedy resolution of industrial dispute, removing the delays in procedure. 1982 had the following things. So, it had following provisions: removal of difficulties in interpretation of appropriate government. So it made easier to understand what do you mean by appropriate government. It defined the term industry. It establishment of the time bound grievance redressal procedure. So we know grievances has to be covered in 30 days. The committee has to answer in 30 days. This was introduced. This time bound was introduced in 1982 where it was 100. So this was old one. Then fixation of time limit of adjudication, right of legal hire, payment of wages to the workmen from the date of award till the final decision, Supreme Court if it is pending with Supreme Court, layoff without permission in mines, modification of provisions, extension. So these are not of that importance. So these were the 1982 provisions or the amendment. Then 210, which are being used in our latest legislation. The wage ceiling of workmen was increased from 1600 to 10,000. We study the supervisory capacity. We have studied the workman definition. So workman's definition, there is a supervisor is covered under definition, but a supervisor who is earning the salary of 10,000 is not the workman. So earlier it was 1600, it became 10,000 in 2010. So direct access of workmen. So this was also, so now workman, if suppose he is dismissed, discharged or retrenched, any of the workmen is discharged, dismissed, he can directly approach the labor court. This was introduced in 2010. Clear? So individual person who is dismissed, discharged or retrenched, he can directly go to the labor court. First to the conciliation. If conciliation is not after 45 days of conciliation process, if he is not getting the relief, he can approach labor court. So this was introduced in 2010. The qualifications of presiding officers of labor court and tribunals was expanded. Grievance redressal committee, which we study in section number 9C, was made for 20 or more workmen, and it was introduced under the chapter number 2B. So it was 210. And empowering the labor court or tribunal to execute the award arrived at the labor court or tribunal. So these were the subsequent amendment and the important provisions as given in Industrial Dispute Act. So we have completed the complete Industrial Dispute Act. You have any doubt, you can ask me. Thank you for the session.